Yeah, all good.
I can. How are you doing? Yeah, it's warm today.
Afternoon, all.
Hi, Kevin. How you doing?
Hello. I'm good, mate. How are you?
Yeah, good.
Can everyone hear me now?
Yep.
Yeah.
All good.
Good. Brilliant. Thank you very much. Just going to get this. Let's see if Alex has got. Okay, where's Alex? All right, let me give Alex presenter status. Alex, are you audible now? I've just given you the mic. If you want to try it. Okay, if for whatever reason it doesn't work, Alex, you may want to leave the room and join via the Microsoft Teams app, but by clicking the link that I sent in our LinkedIn group, in the group messages with the rest of the panelists. To try that, please. Well, I guess this is as good a time as any to get started. So good afternoon, good morning, good evening, wherever you are. Thank you very much for joining us today. This is Startup Legal Q&A. It's our 7th session. However, we've been doing Q&As for startups for just over 4 years now, where we've had, I think, about 600 and almost 650 sessions, where over 280,000 people have tuned into these sessions, and we've helped about 3,000 founders, or rather, shall we say, we've answered about 3,000 questions from founders. The idea is quite simple. Unfortunately, over 90% of startups fail. And the top 3 reasons for that are 1, market fit, 2, running out of money, and 3, not having the right people. But guess what? When it comes down to it, there isn't anything as detrimental to your survival as getting the legalities right, or wrong for that matter. So that's why today we've got a really nice bunch of both in-house lawyers, people who are fractional GCs, perhaps, people who work in-house legal departments, basically, if you want to call them so. Often they're one woman or one man departments, as well as people that come from law firms. We'll do this quite simply. We'll have some quick introductions. We'll then ask the panelists to come up with some do's and don'ts when it comes to early stage legal stuff. And then once they've done that, we will start asking them some questions. For those of you that are on the live streams, please be aware that unfortunately we are unable to monitor your questions live. So if you do want to ask our panelists anything, you'll have to join us on the Microsoft Teams call. The Microsoft Teams call, by the way, it's audio only, which means you should be able to join us via any platform or device. And being audio only, if you're like me, you don't need to spend hours in front of the mirror getting ready for this. On the other hand, you can either join via the via the links on all those live streams, or simply go onto our website, startup2scaleup.club. You find today's session, which is just scrolling down basically, and it's Startup Legal Q&A 07. You click on it, click join. It's a quick registration that gets you a link to your email, and through that link you can then join us here on Microsoft Teams. Once you're here, all you have to do is drop your question in the chat in Microsoft Teams. We then give you the mic and you ask our 4 brilliant panelists that we have with us today. We are only going to be here for the next 52 minutes, so I would urge you not to leave it for last minute to ask questions, because often when that happens, we simply run out of time and are unable to help you. In terms of questions today, as I said, they can be on anything to do with the legal side of running your business, and what it is that you need to both protect your business and defend it from any malicious people, or simply just make sure that you've got everything in order. So in terms of questions, it's quite open. There are no wrong questions, and there's no need to be shy. They can be on anything from how to incorporate to maybe founder agreements, shareholder rights, IP protection, term sheets, compliance, governance, of course, regulatory requirements, non-disclosure agreements, maybe employment law, legal document and templates and contracts, and perhaps disputes between co-founders or investors and boards and all that jazz. It's a learning curve for us all, so please feel free to ask and ask away. If, however, your questions today are not on the legal side of things, please save them for the other conversations we run. So to give you an idea, on Mondays, we help startups with talent. On Tuesdays, it's product and tech. On Wednesdays, it's growth. On Thursdays, it's fundraising. On the second Friday of each month, as you can see today, it's UK startup law. And on the third Friday of each month, it's UK startup finances. Just to clarify, the legal and the finances Q&A are for the UK jurisdictions only, because unfortunately we just don't have bandwidth to have experts for the entire world here on these two matters. And we don't want to be charlatans and pretend we know it all either. So please do bear that in mind. If you want to register to any future session on whichever topic you want them, please simply go onto our website, startup2scaleup.club. You find whichever session you prefer. You then click join, and again, same story as this one. Quick registration, that gets you a link to your email, and through that link, you then may be able to join us. Now, without further ado, some quick introductions. My name's Anton Cole. I'm an Albanian in London working with startups normally right after they get investment. I embed within their teams and help them hire and keep the right people. I also do some growth advisory work with a few other startups and accelerators. And lately, especially, I've been helping some angels and family offices with their due diligence and their assessment. I guess it's probably only fair that we start with the ladies of the house with your introductions, please, ladies. Let's start with Natalie, then Alex, then David, and then Kevin last, since he's been here before. Natalie?
No worries. Hopefully you can hear me all. So hello, everybody. I'm what's called a fractional general counsel. Okay, super. Glad to hear that. So I'm a fractional general counsel. I've been running legal teams since 2012, predominantly in the tech space and of the sort of scale up size, although I've worked for large institutions like NetSuite as well. So I've been responsible for anything from, you know, how to contract in a smart way, all up to shareholder relations and that sort of thing. In my fractional world, I guess what I've been really enjoying doing is helping founders generally make sure they're ready to scale. And so I'll happily share some tips in due course.
Thank you, Natalie. Alex, are you around? Alexandra? Are you audible? We've lost Alexandra, I think. Let me make you a presenter again. Let's try that. Where is Alexandra? Okay. Make a presenter. Let's see. Now it should work. If you try and...
Aha. Hello, can you hear me?
Yes, we can, class.
Hooray.
Go ahead.
Thank you. So yes, my name's Alex Bain. I have worked in and around technology and the telco space for a number of years. I've worked in private practice and in-house in London and in the US. I'm currently a senior lawyer for a telco, and my niche is commercial law and all species of technology agreement. And I also touch on privacy and cybersecurity. So I'm looking forward to this call, and hopefully I'll be able to help.
I'll jump in next.
Yes, David.
Yeah, so my name's David Turney. I'm a co-founder of a regulated boutique law firm, private practice law firm called Avery Law. Interesting, Natalie mentioned 2012. It's the same year, actually, we set up Avery Law. So I've sort of been helping the early stage space since 2012, which is when SEIS Investor Relief Scheme came in. Interestingly, I started my career at a large private practice and then ended up doing very large cross-border M&A deals in quite toxic cultures. And then I moved in-house, and then actually I've sort of flipped that by coming back to private practice and building a law firm that is all built around the sort of corporate life cycle of a startup and its journey towards exit. And I specialize in venture capital and M&A transactions.
Thanks, David. Kevin?
So thank you for having me. My name's Kevin Withane. I'm the co-founder of Impact Lawyers. We've been going since, I guess, the beginning of the year, although we officially launched in May. I've been practicing for 23 years now. Oh God, 23 years. Lived and worked around the world, both in private practice, big UK and US firms, doing corporate M&A, everything from really small ticket to right up to IPOs. Since starting Impact Lawyers or leaving in-house role, which I helped a company do a debt for equity swap. Well, I came in at the end of that, and then helped go public, which has now gone back private. I focus on working with startups, scale-ups, SMEs and VCs, everything from their funding rounds to the day-to-day work. But as a firm, we do employment and other areas as well.
Thank you very much for that, Kevin. Kevin, since you went last on this one, we'll start with you and we'll just work backwards then to David's Alex, and then last but not least, Natalie. What would you say, especially since this is our first session now in the new season? So ideally, if you've seen anything of that lately, but if not, just in general, what is one thing that really boils your blood that people end up doing wrong often in the early stages? And also something that you're impressed or something that you've seen work well. And if we can have one do and one don't from each of you, please. And do not use the same logic for both. So Kevin, David, Alex, and then Natalie, please.
I think particularly at the early stage, it's cost-saving methods that are used, so which leads to cutting corners. Often I see companies don't keep their statutory registers, their company's house filings, either themselves, they've done it themselves and they tend to be incorrect or not done properly, or they use some of these sort of technology platforms out there, which say they provide legal support or legal services, but they're not lawyers, which then when they get to a funding round delays everything because, for instance, the investors, this doesn't look right, the statutory register doesn't match what's in company's house, and it's left to someone like me to then go and clean it all up, which delays the deal, which means they have delayed when they get the money in. So that's something that irks me all the time. Things that I see positive are founders who are organized, who have everything organized, a data room that is clean and easy to use, and they use that as like their filing cabinet for everything that's going on in the business, and it's updated all the time. I think that reduces the red flag risks and helps speed up transactions.
So my turn, I suppose. I was thinking more about just going sort of into early stage fundraising territory. I think Kevin just mentioned the sort of briefly DIY aspect of it. I've seen a lot of issues and things that not necessarily frustrate me, but I suppose frustrate process and investment opportunity. This is quite a specific example, but it's all around a sort of SAFE and an ASA fundraise using some of these DIY platforms and entering into them over a period of time with what's called the SEIS EIS 6-month long stop and having ASAs convert at different points in time so that the older ones get diluted by the newer ones. And I see a lot of founders who get caught up in this issue. When it comes to investment, you just have a completely messy cap table. So like messy cap tables for me are one thing that I find quite frustrating, actually, when I'm acting for the founders and also for the funds, which is quite key. We can probably, I've got another one, but I won't talk about it now, which is the use of ChatGPT to instruct lawyers, but I could probably talk about that for an hour. And then I think positives, I really liked what Kevin said about, that sort of preparation aspect. I think what's really important is finding finding good lawyers, and I'm going to sell myself here and everyone else in the room, but finding good lawyers early on who obviously don't charge you extortionate prices, but who are there to guide you and want you to achieve more than anything, because getting the right advice early on, to Kevin's point, will make you much more better prepared for your fundraise and scale up journey. I'll leave it there.
Thank you very much, David. And rather than go into a Q&A from the audience, because I've just put a question there, you just gave me an idea, David, about, and I'm going to ask you all after, about some tips to find the right lawyer at this stage. But let's go to the latest now. Alex and then Natalie, please. What is one do and one don't that you have for early stage?
I think so. For the do, I've seen this happen before, where there's a rush before launching a new product to determine what rights exist in the intellectual property that's been created. So I think it's important to make sure that you have the right agreements in place with any developers that you engage, to make sure that the IP is properly assigned. And if it's been developed in-house, maybe look to making sure that a record of development's being maintained. So, for example, if you've developed code in GitHub, you'd need to check what licenses, open source licenses, have been used, to figure out if you've had the permission or you actually own what's been created. And sometimes it can be a bit of a haphazard kind of process, and very difficult to determine what ownership rights actually exist in what you've created. So I think that's very important. And then I think on the privacy side, if your product or whatever you've developed involves marketing campaigns, then you have to be careful with making sure you've got the right consents to be able to target your customers. If, for example, you're developing a health app, there may be sensitive categories of data, so that will require a whole different analysis. You probably want to seek expert specialist advice on that to make sure that you've considered privacy by design, storage, security, encryption, anything you need to do under applicable laws to make sure you're complying with your role as data controller or data processor. So yeah, that's a bit of a minefield as well that would need to be navigated carefully.
Thank you very much for that, Natalie.
Yeah, so I mean, definitely parallels with what's already been said. I think the handshake equity deals at the start of a venture, I've seen quite a few founder disputes and issues that I've come across over the years. So carving up your company on a napkin, I don't think is, as much as it might seem sensible at the time, because you are familiar with your co-founders. Then several months or years pass by, and vesting schedules don't get agreed, and there isn't actually a single share being properly issued, can definitely cause some concerns. You're actually trying to do an adult fundraising round. So I think agreeing equity is easy, but documenting it cleanly with leaver provisions, the company house filings, keeping the company books up to date is something I really think is worth investing the time. And it sort of goes on to pick up on what David was saying. And yes, it sounds like we're trying to sell our services here, but ultimately, I think we're doing what we're doing because we've recognised that the sooner we can help, the less these problems will become in the future. So I think, a good thing I have seen is those companies that do sort of come up with scaling ready systems, records, data mapping, and engaging with legal support early on rather than seeing it as an afterthought, I think could be super useful. So whether that's the cap table discipline that David alluded to, contract hygiene, so thinking about sort of centralizing templates, but also having those repositories in a way that means you can actually find things, especially when it comes to due diligence exercises that will be required if you are looking to get that next funding round, for example. Governance habits early on, thinking about that less as a box ticking exercise and just more meaning that you will have the right paperwork at your fingertips. And then going on to Alexandra's points in relation to data protection in particular, I think most businesses now are data businesses. So actually understanding your data mapping within your organization, what is going where, what you hold, where it flows and why, can be super helpful to make sure that you've got the right systems in place, but then all of that information security that comes with it that can become quite costly quite quickly if you don't really know what you've got and what you're dealing with.
Thank you very much, Natalie. Now, team, let's say I come to you for some help, but you are extremely busy and you can't help me, but you want to give me a tip as to how I decide on picking one of your fellow lawyers. What is it that one thing that you would advise me to look out for, or maybe to look for? So since it was David that brought it up, start with David quickly. We then go to Natalie, then Kevin, and last but not least, Alex. One quick thing that founders should look for when going to find a lawyer, and that's of course on top of personal recommendations. Of course, they're the gold. But apart from that, what is one tip that you'd give to founders when looking for a lawyer?
I knew you were going to come back to me, Anton, first. I think of this, and the way I think of it is because I'm also a founder of my law firm. I appoint other professional service providers for our own business. Whether it's an accountant or a tax advisor, you name it. I do what I do with my clients and what I expect of those professional service providers. Even if I'm busy. I do like to give people a little bit of my time to show my experience. That's my investment into a potential client relationship. A lot of more traditional law firms, especially from my background and experience, a lot of people don't do that. They want to charge for it. And also some regulated law firms are obviously often conscious not to provide advice, and there are some regulatory issues around that. But you don't have to provide advice to be able to show your expertise. You can provide guidance, and that's what I try to do. And I look for that sort of guidance in the people I instruct. It's a really important point.
Thank you, Kevin. And then I think we said Natalie and no, sorry. I think we said sorry. I've lost it now. Whether I said David, Natalie, yeah. Which one of you wants to go? Kevin, do you want to go first, and then Natalie, and then after Alex, please? Sorry, I've messed this up.
Sure. Personally, I think you need to look at lawyers, one, who don't charge you for the initial conversation. Some I've come across or been told by clients that they would charge for like a 30-minute call and they didn't understand why. I think look for experience dealing with your type of company. Like I had one client come to us. They went to they went to a very big law firm who really don't do this stage of deal, and they got way over lawyered documents, spent quite a lot of money, and then I had to change it all to be able to work with the BC on the other side. So look for someone who's got expertise and deep experience at the stage you're at. I think you need to get on with your lawyer. You don't want them to just follow instructions. You want them to actually push back on you sometimes, and challenge some of your thinking around the way things are going. Obviously, there's limits of what we can do because we're regulated, so we can only operate within those confines. Pricing matters, so find one that fits your budget, but don't skimp because it is critical. They've got to be professional at all times, and ask if anybody else has used them, and try and, so once you've found someone, search through lists, tons of founders networks, ask if other founders have used that lawyer and their experience as well.
Thank you, Kevin. Natalie?
Thanks. Yeah, Kevin came up with quite a few there, so I'll try and keep it succinct. But I think ultimately, technical brilliance matters, but I do think the relationship matters more. So I like to do the test of, could you picture being stuck in an airport lounge with this person for 3 hours without wanting to kill them? So do you feel like you can instinctively be candid with them, and will they listen to you before they advise you? Will they actually be flexible and pragmatic with you? So ultimately, would you trust the person with your urgent, messy issue at 10 o'clock at night and believe they'll actually find that pragmatic path for you without the added drama?
Thank you very much. Last but not least, Alex, please.
Thank you. Yeah, so totally agree with Natalie and Kevin. You've got to get on with your lawyer. So you're looking for approachability and communication style. Speak to your peers, find out who they have worked with. That's always very helpful. And on the cost side, if you can, try and get a fees estimate. So that will require you communicating your risk tolerance and priorities and the scope of work so that they can provide you with an estimate. And clarify costs and billing up front. Maybe ask for regular fee updates so you can keep a check on where you're going with that spending. And that'll also help them select the right level of seniority to help you and to advise you within their firm.
Good one. Well, thank you very much, Steve. Really appreciate that. Now, just before we go on to some questions that were sent in to us, I guess, quick reset of the conversation. You joined Startup Legal Q&A. It's our 7th session where we seek to help startups with whatever questions you may have as you embark on that legal journey to protect and succeed with your business. The idea is quite simple. There are no wrong questions, and we're all here on a learning curve, so you can ask us anything to do with the legalities of your startup. Things like how to incorporate, perhaps, founder agreement, shareholder rights, IP protection, term sheets, compliance, governance, regulatory requirements, non-disclosure agreements, perhaps employment law, legal documents and templates and contracts, and maybe talk about disputes between co-founders and investors and boards and various other people that you encounter. For those of you on the live streams, please be aware that we are unfortunately unable to monitor your questions there live. So whether you're on LinkedIn, YouTube, Facebook, or Instagram, we are unable to monitor your questions there. If you do want to ask our amazing panelists, you'll have to do it here on our Microsoft Teams call. It's an audio-only call, which means you can join any platform or device, and you can be anywhere to do that. You can find the links of the live streams, or perhaps the quickest way is to go to our website, startuptoscaleup.club. You scroll down a little bit, find today's session, which is Startup Legal Q&A 07. Click join. A quick registration gets you a link to your email, and through that link, you can join us here. Once you're here, you then just need to type your question in the chat. We'll give you the mic, and you can ask our team. And then the same goes for the people that are already here. Please don't leave it for last second, by the way, because unfortunately we'll run out of time. We've only got 27 minutes to go, and often we run out of time and are unable to take questions that people send in last minute. In terms of today's questions, as I said, they're all on legal stuff, so don't feel bad or shy about asking any of them. But if they are outside the realm of UK law, then perhaps save them for the other events we run. So on Mondays, it's talent, Tuesdays, product and tech, Wednesdays, growth, Thursdays, fundraising, second Friday of each month, as you see today, it's UK startup law, and third Friday of each month, it's UK startup finances. That all from 12 to 1 p.m. UK time. You can register to any future session via our website, startuptoscaleup.club. And actually, when you're there, why not also join our WhatsApp community? At the top and bottom of our website, there's a WhatsApp icon, and you can join groups of founders, investors, operators, and of course, our brilliant panelists and mentors too. There's groups that you can ask questions up front and all that jazz. Now, without further ado, we'll go on to our first question. I'll read it out loud. I'll put it in the chat, but I'll read it out loud for those on the live streams. This is, so he doesn't go into detail, but it just says, AI startup in Lancashire, we need help regarding CVC, that's corporate venture capital, proposing low buyout offer instead of investment. And then says, question, our AI startup in Lancaster, Lancashire, is now facing the prospect of a CVC who offered a term sheet, then changed the terms 2 or 3 times, yet has been continuously delaying the investment, and put in brackets, initially agreed to 400k in tranches. After we've now almost run out of cash, they're proposing an acquisition offer at a very low price. Given the intellectual property we have in AI, what options do we have to resist this buyout and protect the value of our company? Is there any recourse for damages or breach of contract? And can we look at other legal remedies? Oh, boy, Jesus. Right. Well, that's an easy question. Kevin, and then perhaps we can go to Natalie, and then David, and last but not least, Alex. Let's keep it to a minute each if we can, please, team. So again, Kevin, Natalie, David, and Alex.
This is not my area of expertise, but I'm assuming the term sheets were non-binding. So I'm not sure what cause of action you had. I'm not sure if there was any lock-up period or exclusivity, or if any money was put into escrow, which sometimes happens when you're negotiating to show goodwill. But assuming there wasn't, then I'm not quite sure what the cause of action would be. So I'm going to defer to the others who may be more experienced in that sort of dispute.
Brilliant. Thank you very much, Kevin. And by the way, for the others as well, there is no shame whatsoever. If anything, you'll be way more respected if it's something that it's not really your bag and you just say pass. So feel free to do that, please. I think we said Natalie, then David, and then Alex, please.
Yeah, so just building on what Kevin said, I think, definitely looking at the term sheet status and whether it was non-binding, I think it's going to be difficult to claim for breach for walking away or changing terms if it is a non-binding term sheet. Equally, Kevin alluded to lock-in or exclusivity. It depends what you've agreed to. If you've agreed not to talk to other investors during that period and they've used that time to run you down, is that a breach of exclusivity? It might give rise to a contractual claim, but only if it was binding. So it'd be quite a tricky one to try and prove. I don't know if there's any sort of side letters, emails, promises that are made sort of separately that you can document. I mean, ultimately, I think the sort of things that you'd want to discuss with a specialist corporate disputes lawyer would be something like, is there a claim for misrepresentation or negligent misstatement? So if they made some specific factual statements like the funds are approved and are going to be released on a certain date, and they turned out to be false, and then you reasonably relied on them, there could be a claim. There is something called promissory estoppel as well, which is an equitable recourse that might be available, but it's only in limited circumstances, and you've got to effectively have relied on what you perceive as a clear promise, suffered loss, and then have to go to court. But the court's set a high bar for this, and it can be really expensive. We don't really have, unfortunately, under UK law still, unless somebody corrects me, this concept of bad faith negotiation. There is something that's called economic duress, but it's also quite difficult to prove. So I think the sort of commercial practical steps that you probably want to think about are, if you're not still in an exclusivity period, then looking for other investors or strategic partners who might value your IP more highly. I'm conscious that you're running out of cash quite quickly. I don't know if you've got any convertible loan notes. I don't know if you could think about like an emergency safe from angel investors to buy you a little bit of time. I don't know what your current sort of shareholding looks like. I'm sure Alexandra will probably pick up on the IP point, but I think just having a look at if your IP is your main asset, making sure that that documentation is looking good and your protections are all there. Because ultimately, I guess if CVC want your technology, that IP portfolio evidence of other interest might be able to help you push back or negotiate better terms. But that's all I can really think of, I'm afraid.
Thank you very much, Natalie. David, and then Alex, please.
Yeah, I mean, I totally agree with Natalie and Kevin on the sort of, if the term sheet is non-binding, you've probably not got a snowball's chance in hell, as they say, in bringing an action, and you probably wouldn't want to, given the financial involvement of any dispute. Your best course of action in this scenario, and if you are a director of the business, your best course of action is to probably manage insolvency risk. So there is a sort of test, and I see this with a lot of startups where their runway is drying up just prior to fundraise. You've got to think about that test if there's no white knight situation in terms of funding. That's probably a more important piece of navigation with your existing shareholders and creditors, if you have them. That's where the law comes from in terms of insolvency risk, as opposed to acceptance or being forced to accept, obviously, a new term sheet you don't want to get into. Having said that, you probably need to look at any existing shareholder arrangements, depending on requisite shareholders and whether someone can force a drag scenario. These are all things you sort of need to consider. I would assume if you control the company, that wouldn't be the case, but you never know. So that's something you would need to work with a lawyer. I will leave the IP piece to Alexandra as a specialist, but I do note, and it's probably one that she's going to mention, there was a very famous Notting Hill tote bag case recently in the past year or so, where IP was not dealt with prior to liquidation and ended up sitting with the Crown. And that is something you need to be careful of. So you do need to do something with the IP prior to any liquidation. So I'll leave it there.
Thank you. And just before we go to Alex, sorry, Alex, David, you mentioned insolvency. Now, you'll have to forgive my ignorance, but are you saying that, maybe they may want to go through insolvency rather than kind of sell the company to the CVC? If you don't mind just clarifying that bit, please.
Yeah, no, sure. No, it's essentially a test. So if you are a director of a private limited company, I'm assuming in this case, you have to make a decision financially as to whether the company, and I'm not an insolvency specialist, but I believe the test is somewhere along the lines as satisfying your debts as they fall due. And can you meet your liabilities or otherwise make other arrangements to meet your liabilities? If you are worried about that, and when you get to that sort of threshold test, you have a duty to your creditors rather than your shareholders. So you have to take actions to either wind the company up or appoint an administrator. So that is the insolvency sort of point I'm talking about. A lot of early stage companies, when they fail, they are forced into an administration process. That is what the failure is essentially. And that's when creditors will come and agree a penny on the pound type deal where someone makes the best offer. It's known as a fire sale in the startup world for the assets of the business. This valuable IP. That's not a particularly great situation. So I hope that helps.
Thank you, David. And last but not least, Alex, please.
Thank you. Yeah, so I think my co-panelists have dealt with the other points outside of IP very well, and I can't really add anything, so it's not my area on funding alternatives or the insolvency piece. But on the IP, yeah, I mean, that could be the silver lining here. If you do have to walk away and potentially find another investor, you can walk away with the IP in your AI intact, hopefully. But obviously that will depend on how far you've gone with ensuring you've got the necessary protection in place. So you may want to seek specialist advice on that to make sure that you've protected everything you can, considering that that's the main value proposition, if it is.
Here, thank you very much for that. Right here, I guess we can go on to another question. I will put that into the chat so that the panelists can read it, but I'll read it out loud for the live streams. And again, just reminding everybody that is following us through the live streams, whether that's LinkedIn, YouTube, Facebook, or Instagram, we are unable to monitor your questions. They're live, and there's no point in you either messaging me or, I don't know, commenting underneath the live streams or emailing, whatever it is. Please if you do want to ask us anything, we're going to be here for the next 15 minutes only now. But you need to join us here on Microsoft Teams. Quickest way to do that is go to our website, startuptoscaleup.club. Scroll down a little bit, find today's session, which is Startup Legal Q&A 07. You click join, it's a quick registration. That gets you a link to your email. And through that link, you can join us here on Microsoft Teams. It's audio only, which means you can join us via any platform or device. Once you're here, then simply post your question in the chat. We'll give you the mic, and then you can ask the team. So the next question is about duty of care in confidentiality agreements with advisors. This is from somebody in London. She's got a medtech startup. They're at seed stage. She says, we've had an advisor sign a confidentiality agreement. And then she's put in brackets, my co-founder had found a template online, but we suspect they have disclosed our sensitive business information to a competitor. What are the legal consequences for breaching the duty of care in confidentiality agreements, and how can we hold the advisor liable for any harm caused by the breach? Maybe we can start with the ladies on this, so we can go to Natalie, and then Alex, and then David, and last but not least, Kevin. If we can keep it to a minute each, please, so that we can go or at least another question after that, that would be great. Take it away, Tim.
Sure. So NDAs, hey, you know, some people would think that they're not necessarily worth the paper they're written on. However, if this advisor has signed an NDA and then disclose information outside of what's called their permitted purpose, then, you know, it would constitute either a breach of contract if it relates to that confidentiality agreement, or a breach of confidence anyhow. I guess ultimately here, it's what do you suspect that they have been disclosing, and what is the likely loss to your organisation? I think the practical step here is more acting as a bit of a sort of deterrent stick to stop them from doing that going forward, depending on what they've already done and whether you've got any evidence to show loss and issues for the company so far. So I think ultimately what you'd probably want to do is write them a cease and desist letter that essentially says, we've heard that you've been disclosing confidential information that you're not authorised to do. You want a written explanation from them. They want them to cease all further use and disclosure, ensure they raise anything that they may still have, and that they confirm that they have done that. And then essentially you're going to say that you're going to reserve all your rights. The likelihood of you trying to then bring a claim in court, you know, whether it's an injunction or trying to seek damages, you know, I think is just one of those things that isn't commercially viable unless it's something that's really, really valuable to you and your organisation. But generally, these cease and desist letters and threats tend to have at least some effect of stopping that person from carrying on the activity. So that's what I'd suggest.
And yeah, just off the back of what Natalie said, I think that's the priority, to minimise further exposure. So cease and desist, I definitely agree with that approach. And obviously, you'd need more than a suspicion to be able to bring a claim. So you'd have to prove that you've suffered loss or damage through what they've done. And then different legal remedies may depend on the nature of what they've disclosed. It could be a claim under the confidentiality agreement, or if it's a trade secret, if you could prove it was, for example, an algorithm or some kind of technique that they've disclosed, then you'll have other potentially legal remedies under statute. But yeah, I think first thing is to try and mitigate the risk of further loss or exposure through cease and desist.
Thank you, Kevin, and then David, please. Are you with us, Mr. Woodane?
Can you hear me?
Now we can.
Yeah, okay. Don't really have much more to add. I'd suggest getting a lawyer to write a letter for you for a cease and desist. You can, if you think they're still sharing information, try and ask to seek injunctive relief. Typically, you should have that in your confidentiality agreements, wording there around that. But usually, and then afterwards, it would be a claim if you think they have shared your confidential information and you've suffered damages as a result of that. But it depends on your funding. You're going to be that costs a lot of money to go to court. So yeah, the cease and desist is the first step they should be taking.
Thank you, Kevin. And last but not least, David, please.
Yeah, I won't add any more sort of legal remedies because I think they're all covered. I think just in terms of practical steps. Oh, actually, one legal thing that's just come to mind, which I've just actually witnessed with a client, is a sort of data breach related notification to the ICO. And I'm not a data or privacy lawyer, but I think there's something like a 72 hour window where there is a suspected breach where you have to notify the ICO. So if you have reason to believe that there could have been personal or sensitive data, bearing in mind that I think it said it was a medtech business, there's sometimes a lot of personal sensitive information there. That's something to consider. So that sort of goes hand in hand with the cease and desist letter. You could seek in that letter or ask them to actually spell out what information, so that you can then make that assessment. That will all help in terms of if the ICO ever did turn around and say, you are in breach of UK GDPR or whatever we call it these days in the UK, then you can show that you've taken adequate measures to protect that personal or sensitive data. So that's probably all I have to. Oh, and then maybe whether you've got stakeholders, shareholders, whether there's any provisions in your shares agreement with respect to potential fallout that you might need to notify them. So something to look at.
Thank you very much, Tim. Here's my quick take, and obviously, as you all know, I'm not the expert here, but from what I've seen out there and what I've been told previously, is that unless this person that has breached that NDA has got some serious money or is a representative of a business with serious money, you haven't really got much to stand on, because you'll end up spending loads of money going to court for what? For nothing. Two, unless you want to just damage them out of spite because of what they've done to you, and maybe if there is anything criminal there, then again, you can't really do much to them either. And last but not least, I've seen a case. Now, I don't know all the ins and outs because I wasn't really much interested, but it was somehow they went on a quest to prove that actually either the business or the investors that they passed information to had done that on purpose pretty much from the beginning, and had asked this person that breached that confidence so it was almost like them sending them on a mission, and they somehow managed to prove it, and they managed to get money from this business rather than the people that had breached the confidentiality. And another thing that I've learned is that it's quite hard to actually prove that somebody has breached an NDA, and then to prove that it was going to damage your business and all that jazz. So yeah, I'd be really careful with that. Okay, we've got only 6 minutes to go, so we'll quickly go to our last question. I think we can start with David, then Alex, then Kevin, and then Natalie. This is on SEIS, EIS compliance. Again, a health tech startup in London. Goes on to say, our health tech startup in London is raising its first SEIS round to develop an AI-based diagnostics tool. How can we assure compliance with the SEIS rules while structuring our initial share issue, particularly around the no prior trading rule? Additionally, what measures should we take to avoid breaching the 150k SEIS funding cap? I think it's now increased, isn't it? Especially if we plan to raise an EIS round shortly after. how can we balance SEIS eligibility with securing IP ownership given our early reliance on founder developed technology? So maybe we can, let's go on to David. God, I can't remember if I said Kevin or Natalie, or tell you what, David, Kevin, Alex, and Natalie. Let's go in that order. 1 minute each, please.
Sure. This is a subject you could talk about all day on, and it's also quite a delicate SEIS rules. Any tax relief rules are not to be treaded lightly, because you're dealing with HMRC. So obviously, first off, Anton, you're absolutely right. The limit for SEIS has now gone up to 250 in total, and it has to be raised from the no trading rule. I think is, so the commence of trade, first trade sale or incorporation is now 3 years. In order to bridge an SEIS and EIS rule, the fundamental rule, and I talk about this a lot and guide founders on it on LinkedIn if you want to follow me, is that you can do a dual raise round as long as you leave at least 1 day apart between the SEIS and the EIS round, and you do not receive into your bank account any EIS funds before you have issued the SEIS shares. It's an absolute fundamental rule which I see breached all the time, unfortunately. So that's probably fundamental. I'll leave it there, and I'll let other people have a sort of a say. Sorry.
That's all right. Kevin, Alex, and then Natalie.
Yeah, this is a really technical area. Literally on this point, I'm discussing this now on a funding round that I'm working on, where there's SEI shares, EIS shares, and then just ordinary shares in play, and it's getting the timing right for the closing the SEIS. I would say you speak to your accountant as well, or make sure they understand it, or if you don't have an accountant that understands the tax piece of this, then you need to work with an accountant to do that. But I'd probably reiterate what David has said there. I don't think there's much more to add on it in the time we have.
Thank you, Kevin. Alexandra?
Thanks. I will pass on this one. It's not my specialism, and I think my co-panelists will cover it much better than me.
Thank you, Alex. And last but not least, Natalie, please.
Yeah, I don't think I've got much more to add other than just probably practical points, just thinking about HMRC advanced assurance applications and things, and just getting that in before you start pitching to investors, because like some angel investors aren't likely to invest without that already kind of in place. And then, just having things like board minutes, invoices to evidence, anything that can help with that sort of no prior trading sort of requirement piece as well can be quite useful, even if it feels a little bit trite. I think David already mentioned that sort of time period between SES and EIS tranches, and I think that's something that can sort of catch people out if they're not sort of mindful of it. And then maybe the final thing is just think about just be mindful of things like sort of state aid, other funding, those sorts of things. So if you have certain grants that you may have received as an organisation, because they can also count to that 250k limit. So just make sure you're keeping that running total and the paperwork that goes with it, so that doesn't start to cause a headache when you're sort of knee deep in the actual funding round.
How do you get the assurance, the SEIS certificates, Natalie? And I suppose it's quite straightforward, isn't it?
Yeah, I mean, basically it's like any of these sort of regulatory assurance sort of things. You've got to kind of, I think there's an online form that you've got to do, and then you kind of submit like a business plan, financial forecasts, that sort of thing, and just I guess sufficient information for them to understand what you're trying to achieve, and essentially they'll just verify that information against their checklist, and hopefully if you've kind of done it competently and it gives them what they need, it usually takes about a month or two. Maybe the other guys have got a better understanding because they're doing it more regularly than I've done it. But yeah, I think it just sort of comes through, and then you can kind of share that with your prospective investors to give them that comfort.
Okay. Well, thank you
Can I
very
just
much.
can I
Yeah,
just
go on.
quickly say, Angela, I was just going to say
you
to Natalie's point, just on the time frame, that HMRC say it could take a month. You do get some back in a day, believe it or not, if it's very clear cut. So the more complex your sort of prior trade and IP ownership situation is, you can imagine it takes a lot longer. So yeah, keep your company clean.
Brilliant. Well, we are now 1 minute over the line, which means it's time for some parting words. Let's start with the ladies of the house, if we can, please. So Natalie, Alex, David, and then last but not least, Kevin. Your parting words before we let you go?
Without that guidance, I guess, I mean, ultimately, I think, don't underestimate the power of good record keeping and evidence.
Thank you. Alex?
Protect your IP. Make sure you've got the right protection in place from the start.
Thank you, David.
I feel like I'm on the spot here. I'm going to say, come and have a free consultation call with one of us.
Good one. And last but not least, Kevin. And Kevin, by the way, for that message you sent me, if you haven't sorted it out yet, one, please do feel free to post it in our WhatsApp community, and two, do let me know and I'll find a way to come help you. But can I have some parting words from you, please, sir, as well?
Yeah, make sure your house is in order. Keep your statutory registers. If you don't know what that is, reach out to one of us. We can probably give you a template for free. And don't scrimp on your legal costs to the detriment of having problems later down the line.
Here. Well, all four of you have been absolutely brilliant with your wisdom and time today, and I'm very grateful. I'm also thankful to everyone that tuned in. Those of you that did it via the live streams, next time, please join us here live on Microsoft Teams. It's audio only, which means you don't need to spend an hour in front of the mirror doing your hair. And you can actually join from anywhere via any platform or device, whether, I don't know, you're cooking lunch in Liverpool or walking your dog in Surrey or changing baby nappies in Edinburgh. It doesn't matter. You can easily join from anywhere. Now, as far as just before actually I go to my parting words, just a couple of quick reminders. Number one, we run 6 regular sessions helping founders with whatever challenges you have. Those are Mondays talent, Tuesdays product and tech, Wednesdays growth, Thursdays fundraising, second Friday of each month, as you can see today, it's UK startup law, and third Friday of each month, it's UK startup finances. They're all from 12 to 1 p.m. UK time, and you can actually register to any of them via our site, startup2scaleup.club. Once you're there, you may also want to join our WhatsApp community. At the top and bottom of our site, you'll find links, or an icon rather, a WhatsApp icon where you can actually join us, and there you'll be able to connect with other founders, investors, operators, of course, our specialist mentors and panelists. What I'm also going to do right now in the chat here, I'm going to put the link to a specific WhatsApp group for the legal Q&A. And there, if you join that, one, you'll be able to post questions ahead of each session, as well as discuss whatever we talked about and whatever we touched on in the live Q&A. You can actually talk about it later and, of course, be part of connecting with each other too and getting help that is quite valid. So I've just posted that in the chat. Please feel free to join it. Again, remember, we are unable to monitor questions on the live stream. So next time, join us live here. You can do that via our website. And as far as my parting words are concerned, just remember the startup journey can be both exciting, but also quite challenging. So try to have some fun in the meantime and be kind to yourself and everyone else for that matter too. Otherwise, huge thanks again. Have an amazing weekend ahead of you. And hopefully we'll see you on Monday for Startup Talent, where we'll help you find and keep the right people. Otherwise, thanks again and God bless you all. Bye for now.